is collected. One of the most important points that Dr. Peer makes in his article is that a problem comes about because of the way things are done, that we don't have the evidence needed to decide will contests and other matters of that kind through the testimony, through the direct evidence, and what we usually depend upon are presumptions and circumstantial evidence. And I would ask everyone here, would you like your estate, that maybe is going to your children, your spouse, or whoever, to be decided based upon presumptions and circumstantial evidence? Wouldn't you like to make sure that it's done the way you want it done? Wouldn't you like to have some input into how these matters are handled? Today, you don't have that opportunity. Several legal reforms have been proposed. You probably haven't even heard of them, and you haven't had any chance to give input to them. There's been no real public dialogue concerning them, and I'm hoping we can correct that. Now, Dr. Hall's article, which came out in June of this year, is an exceptional article published in the Clinical Geriatrics Journal. In this, and I make reference, and when you have time, if you haven't already done so, I'd like to ask you to go through it. He identifies the questions that should be asked. You know, today, if you're competent, basically no questions need to be asked at all. For example, if you make a change to your will while you're under morphine and a do not resuscitate order, you should be asked, why did you make the change? And that's what Dr. Hall says. Why did you make the change? You know, who's impacted by the change? Nobody has to ask any of those questions. If you can sign it and somebody can witness it and say that you are who you are, basically, there's very little required. They don't have to ask those kind of questions. Furthermore, the person's asking them, who's asking? Is the representative of the beneficiary of the change asking you the questions? Should you be able to trust that individual, or should you get somebody objective in it? Now, this was addressed by several authorities too, including the State Medical Association and the American Medical Association, where they said basically that you need to have somebody go in there whose first contact is with you, the person making the change or making the will up, not with somebody who's trying to influence you. And Dr. Hall emphasizes that also in his article, where he talks about how people who are trying to exploit you in these kind of situations will try to take advantage to influence the people who they think can influence you, such as attorneys and doctors. Another important point that Dr. Hall makes, these Dr. Halls make and others, and there's plenty of good reading here, he writes on the first page, unfortunately, most doctors, even those who primarily see patients for advanced years, are not knowledgeable about key issues surrounding testamentary capacity, much less the fraud, the undue influence, and all the other things. A study in 2002 found that only 7% of general practitioners, psychiatrists, geriatricians, and medical students nearing completion of their training could answer basic questions regarding testamentary capacity. Only 7%. That means 93% of the doctors out there who might be involved in these situations have no idea about what they're doing. That's got to be corrected by a protocol. That's got to make sure that somebody who is knowledgeable, who knows what they're doing, asks the questions that Dr. Hall, and does so in a way that protects you from opportunists who will be trying to influence people in the examination. I can go on for hours on this. So what I'd like to do is take your questions. If nobody has any questions, I can continue on with some questions that have arisen in this case.